2 no more than 10 years in the Texas Department of Corrections. Fine may be assessed at up to $10,000. You understand that?
Yes, sir.
Got some plea documents here. The first one's going up, your plea agreement. There's a signature on the line above where it says defendant signed Derek Spencer. Is that your signature? Can you see it right there,
Sir.
Derek?
Yes, sir, it is.
Is that your signature?
Yes, sir.
All right, Mr. Spencer, they're also signed by Jeff Sanders, one of your attorneys, and Ms. Anderson, state's attorney. You have a plea agreement. I'm going to identify these plea papers. You got a plea agreement. If you plead guilty, state's recommending your sentence at 5 years deferred adjudicated probation. You got a document you signed along with your attorney setting out an acknowledgement of admonishments, setting out the full range of sentencing. Not less than 2 years or more than 10 years of the Texas Department of Corrections Institutional Division, fine up to $10,000. Of course, you've got a plea agreement for 5 deferred. Do you understand all 5 admonishments under the acknowledgement of admonishments? You and your attorney signed right below the 5th one.
Yes, sir, I do.
You understand you've also signed a waiver of trial by jury, telling the court you understand you have a right to a jury trial, but that you're knowingly waiving your right to a jury trial and just requested a trial before the court on your plea of guilty. Do you understand that?
Yes, sir.
You signed and sworn to a waiver of confrontation with witnesses. You've signed and sworn to now a stipulation of evidence, states 2. Do you understand that document up on the screen? That is a written judicial confession under oath by you to all the allegations and the charge in the indictment. Do you understand that?
Yes, sir, I do.
Did you sign and swear to that stipulation of evidence of your own free will and sign and swear to it voluntarily?
Yes, sir.
Then we've got an agreement to stipulate testimony. We've got a form for a waiver of motion for new trial, waiver of appeal, signed by you and your attorney. Request to allow a waiver of the pre-sentence, which is approved by the court. We've got a document, trial court certification of your rights to appeal, signed by you and signed by your attorney. Check. This is a plea bargain case and you have no right of appeal, and the defendant has waived the right of appeal. Do you understand that document?
I understand.
Y'all, there's also an advice that you signed and sworn to, which sets out the advice you've received from your attorney on your right to appeal. Of course, you've waived your right to appeal in the waiver signed by you and signed by your attorney. Do you still wish to go forward on your plea of guilty to this indictment, charging you with possession of controlled substance, a 3rd-degree felony, without a jury?
Yes, sir.
All right, we'll go through and ask you some questions. Do you read, write, and understand English?
Yes, sir, I do.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir, I haven't.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir, I don't.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir, I haven't.
Do you understand everything you're doing in court today?
Sure do.
Have you been over everything you're doing in court today with Mr. Ellis, your attorney?
Yes, I have.
Been over everything about the facts of your case with Mr. Ellis?
Yes, sir.
Is he competent, Mr. Ellis?
Yes, sir.
Any evidence of incompetence, Mr. Gilmore? Any evidence of incompetence, Mr. Gilmore?
My apologies. No, Your Honor, there's no evidence.
That's okay. All right, court. No, State's counsel signed his consent and approval of the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed or signed or sworn to by the defendant, signed by his attorney. All right, now you do understand all the allegations and the charge in the indictment, Mr. Spencer, for possession of a controlled substance, 3rd-degree felony. Is that correct?
Yes, sir.
And you do understand all of your plea documents you signed or signed and sworn to, all signed by your attorney. You understand all those documents?
Yes, sir, I do.
Do you have any questions for me about anything?
No, sir, I don't.
All right, in cause number 241-1160-20, what is your plea today to the indictment charging you with possession of controlled substance, a 3rd-degree felony as alleged in the indictment?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason? Are you pleading guilty because
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir, I am.
Has anyone threatened you in any way or promised you anything to plead guilty?
No, sir, they haven't.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, sir.
Are you pleading guilty because you have any type of delusion in your mind or some type of unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, what do you have, Mr. Gilmore?
Your Honor, the state will offer states Exhibit 1, the signed plea papers, and states 2, the stipulation of evidence, and states 3, the discovery compliance forms.
No objections.
With no objection, states one, all the plea documents signed or signed and sworn to by the defendant, signed by his attorney, all admitted in states one, states two, the signed and sworn to stipulation of evidence, written judicial confession under oath by the defendant to the allegations of the charge in the indictment, states three, discovery compliance, all admitted into evidence without objection. The court, having received and accepted state exhibits 1, 2, and 3, the court does further find that the defendant's plea of guilty entered to the indictment in this case was entered by the defendant to the indictment in this case freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty. However, the court does withhold a finding of guilt as to the defendant and will move to sentencing. Mr. Gilmore.
Your Honor, the state will offer states Exhibit 4, a digital copy of the discovery, which I will bring down to the court reporter immediately following the Zoom
That's
hearing.
fine.
No objections.
With no objection, states four is admitted into evidence. The court in this case then, based upon the defendant's plea of guilty to the offense of possession of a controlled substance as charged in the indictment, a third degree felony, evidence presented and admitted into the record by the court does find the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. However, the court does withhold the finding of guilt as to the defendant follows the plea agreement, the recommendation of the state, sets the sentence in the case at 5 years, deferred, adjudicated probation, no fines assessed, court costs ordered paid, restitution ordered Department of Public Safety for the lab fee analysis in the amount of $180. Any legal reason for formal sentencing?
No, Your Honor.
Finding none, the court does formally pronounce the sentence. Court receives and accepts the defendant's plea of guilty to the offense alleged in the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily. The court finding the evidence in the record fully sufficient to support the defendant's plea of guilt to the offense alleged in the indictment. However, the court does withhold a finding of guilt to the defendant follows the plea agreement, the recommendation of the state, and sets the sentence at 5 years, deferred, adjudicated probation, no fines assessed, court costs ordered paid, restitutions ordered DPS lab in the amount of $180 for analysis of the controlled substance. Sentence is formally pronounced following the plea agreement, 5 years deferred, adjudicated probation under all the terms and conditions assessed by the court. You have filed, Mr. Spencer, with the court a waiver of your right to appeal. It waives and gives up your right to appeal. It waives and gives up your right to file a motion for new trial. Are you presenting that waiver to the court now freely, intelligently, knowingly, and voluntarily?
Yes, sir, I am.
Court receives the waiver of appeal, giving up the defendant's right to appeal, signed by the defendant and his attorney, and the court receives and accepts the waiver of a motion for new trial, also signed by the defendant and his attorney. Ours in both file and the papers and clause. Under the plea agreement, the court's followed, Mr. Spencer. Your sentence having been assessed at 5 years, deferred, adjudicated probation. That means for the next 5 years, up to the next 5 years, you'll be on the court's deferred, adjudicated probation under the 70 or more terms and conditions assessed by the court. If you do violate any of the terms and conditions, like failing a drug test, failing to report, or any of the other terms and conditions, the state will file a motion to adjudicate your case. That'll cause a no bond warrant to go out for your arrest, and there would be a hearing held before the judge of the court, not a jury trial. If the evidence convinced the judge you had in fact violated any term and condition of your deferred adjudicated probation, as I've said, like failing to report, failing a drug test, or any of the others, the court would grant the state's motion to adjudicate, go back and find you guilty of the third degree felony offense of possession of controlled substances alleged in the indictment. Then, because you were on deferred, the court could assess your sentence up to 10 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. You understand all that?
Yes, sir, I do.
The court receives and accepts the waiver of appeal, waiver of right to file a motion for new trial, formally pronounces sentence at 5 years, deferred adjudicated probation, withholding a finding of guilt, receiving and accepting the defendant's plea of guilty to the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily.
Sir.
Marcella, the court's probation officer, is a party to this Zoom hearing. At some point, you'll be booking out of jail. Now, when you do book out of jail, I don't know when it'll be, but when you do book out of jail, you have to report directly to the probation department to meet with your supervising probation officer. Who will that be, Marcella, if you know?
Your Honor, he has been assigned to Officer Michelle Vasquez, and he will meet with her September 3rd at 2:30, and she will also call Mr. Spencer.
All right, Mr. Spencer, then you should have a number. If you don't, Mr. Ellis can provide the probation department with your cell phone number, because you have to report to the probation department. I don't know when you'll book out, but once you do book out, let me be sure you've got this date on the record. You have to call your probation officer. Do you have, what's the name, her name, Marcel, I'm sorry.
Officer Michelle Vasquez.
Marcel Vasquez, she'll be your supervising probation officer. Mr. Ellis will be sure you get this done. You have to contact your probation officer at the number that's going to be on a sheet of paper you'll get when you book out of jail. You have to contact her by phone, and then she is going to give you a date by which you have to appear personally with her for her to go over your 70 or so terms and conditions of probation. Do you understand that?
Yes, sir, I do.
Now, this is really important, because when you book out of jail, if you don't call her at that number, right after you get out of jail, like, I don't know when it'd be, you may book out tonight. If it's this evening, in the morning, you have to call her at that number at the probation department. She'll give you the date and time you're ordered to report in person by the court, which is what day?
September 3rd.
What date, Marcella?
Your Honor, it's September 3rd at 2:30.
September 3rd at 2:30. You have to be in your probation officer's office, for the obvious reason she has to go over in person with you the 70 or so terms and conditions that you have to follow in order not to violate your probation. Do you understand that?
Yes, sir, I do.
Of course, you're going to have drug testing requirements, probably some outpatient treatment requirements for drug abuse rehabilitations. There'll be a lot of requirements. Just be sure that on that date that's in the record now, one, when you book out of jail, call your probation officer at the number you're going to have, and then report to your probation officer. She'll give you this date, but on September 2nd at 9 o'clock, you have to be in her office. If you fail to contact her and you fail to be in her office on that date, then what'll happen is the state, Mr. Gilmore, he'll file a motion to adjudicate your case, send me a violation report. I'll sign a no bond warrant for your arrest. And then there will be a hearing, and if the state proves you did not contact your probation officer, or you did not report to your probation officer when ordered, or you violate any other condition like using or possessing a controlled substance, failing a drug test, then the state can use that to file a motion to adjudicate your case. If they prove you violated terms and conditions of your probation, the court would grant their motion to adjudicate and then go back and find you guilty of the offense charged in the indictment. Then, because you were on deferred, the court could assess your sentence up to the maximum 10 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. You understand all that?
Yes, sir, we don't have to worry about nothing about that. I do understand.
Sorry, did you get it?
I understand.
Okay.
Judge,
Yes.
Judge, I would like to make sure that my client is clear and he does understand this, that as soon as he's released from jail, he has to call Michelle Vasquez as soon as he's released, but then he's going to report to her September 3rd at 2:30.
Yes,
And
sir,
the reason I said that is because I believe once the court informed him September 2nd at 9 a.m. So I didn't want him confused on that.
Well, let's be sure it's clear for the record from my probation officer, Marcella. What date is he supposed to appear?
Your Honor, he will report to Officer Michelle Vasquez September 3rd at 2:30.
September 3rd at 2:30. Do you have that date and time now so you understand when to personally report to your probation officer?
yes, sir, I do.
All right, you understand if you fail to report in person to your probation officer on that date, it's going to trigger a no bond warrant for your arrest, and the state can use your failure to report to your probation officer to try to adjudicate your case, revoke your probation. If that takes place, I can sentence you up to 10 years. You understand all that?
Yes, sir, I do.
You have any other questions for me?
I do, Judge.
Okay.
Judge, I would like to inform your probation officer that my client is also in jail on a theft by check warrant out of Kaufman County, so it may be a couple of days before he is released from jail.
Okay, you got that, Marcella?
Yes, Your Honor.
Thank you, Judge.
All right, anything else, Mr. Gilmore?
Not from the state, Your Honor.
Anything else, Mr. Ellis?
No, Your Honor.
All right, we'll be in recess and remember to report on that date order. That's real important. So you don't end up in the Texas Department of Corrections. You with me on that? You understand that? In other words, I just want to be sure you understand, Mr. Spencer, it's real important you report on that date.
Yes, sir, I do understand.
You call your probation officer and report on that date. Okay, we're in recess.
Thank you, Judge.
All right, thank you, Mr. Ellis.